Welcome today. We're going to give everybody just a few minutes to join. So this is your official permission slip. You can grab a coffee or tea or whatever. Just make sure you're close by. We're not going to judge you. Get comfy, settle in. We've got a lot of exciting stuff to cover today. I promise it's going to be worth your time too. If we haven't met yet, I'm Kim. I'm the Director of Account Management here at HR Covered, and I'm so excited to co-host today's session. We've got two absolute pros with us. I'm going to tell you all about them. To all of our amazing clients, welcome back. It's always so good to see you. If this is your first time joining us for a webinar, really quick intro for you. HRC Law supports organizations across Canada with risk mitigation, legal, compliance, proactive guidance, all kinds of great stuff. They help small to medium-sized, even large businesses. Really, if you're in a business, you've got workers, they are the people you want to talk to. They can help you navigate all the tricky stuff, reduce legal risk, and help save you time and money. Very, very great people to have on your side for sure. I'm going to tell you very, very quickly. This presentation today is for educational purposes. It does not constitute legal advice. Employment law is very, very complex. And of course, it's specific too. It's going to be based on your situation and your scenario. And we really, really encourage you that there is guidance that is definitely needed on how any of these developments are going to apply to your specific situation. So I always like to put that in there right away. But don't worry, because if you have questions, you're going to be able to throw them in that chat down there. We're going to get to as many of them as we possibly can today. If we don't get to yours, though, we will be reaching out to you after the webinar as well to get in contact with you and help you out with that. So let me tell you a little bit about who is here with me today. I can tell you, Tom and Labisa, if Canadian employment law has ever thrown you a curveball, has ever thrown it to anybody, they've seen it, they've handled it, they've probably prevented it from turning into a full-on workplace soap opera as well, which is really, really cool. So a little bit about Tom. He's been an employment lawyer. He's for 15 years, over 15 years. He advises employers and employees all the way across Canada. He's your go-to for anything to do with contracts, investigations, wrongful dismissal disputes. He's represented clients before courts and tribunals across the country. So in other words, calm, strategic, and exactly who you want in your corner when things get complicated. And moving on to Labisa. Labisa's an employment lawyer. She's got over 10 years helping organizations from startups to multinationals stay compliant and ahead of risk. She's really known for employment standards, human rights, and strategic workforce decisions, especially when modern realities like remote work or AI, how much have we been hearing that lately? It's changing the rules faster than policies can sometimes keep up. So we've got some great support for you here today. By the end of today, you're going to know everything that's changed from the legal employment standpoint for 2025, what it means, how to stay ahead of the curve. Before we dive in, though, two very quick things. This webinar is being recorded. We're going to send you a copy of the recording afterwards. You can rewatch this. You can share it with your team. We're going to also wrap up with a Q&A. So drop your questions in that chat as we go. There's no such thing as a silly question, and I would say only really, really expensive assumptions that you don't want to make. All right, that's enough from me. Tom and Labisa, take it away.
Thanks for that awesome intro, Kim. Appreciate that. Hi, everybody. Welcome. Good afternoon. Just before we dive in, just briefly, I want to frame how today's session is structured. First, I'll be focusing on case law developments and specifically 2025 decisions that are in a way reshaping how courts interpret employment contracts, especially around termination clauses. After that, Tom is going to talk to us about legislative changes, including some new statutory obligations across provinces and in federal workplaces. So, 2025 was a particularly significant year, if I can say that, for employment case law across Canada. What we're seeing in employment law is a lot of structural change in how courts interpret employment agreements. And these cases have created what many lawyers are now calling an enforceability crisis in employment contracts, where termination clauses that were once considered safe are actually now being struck down. So if your contract language is ambiguous, if it's overly broad, if it's theoretically capable of violating some minimum standards, even in like a hypothetical situation, courts are increasingly invalidating the entire clause, which then translates into larger than ever payouts for terminated employees. So before we move into, sorry, can we go to the next slide? Thank you. Before we go into the case law, I want to begin with a bit of a primer on employee termination entitlements and termination clauses, since we need to have that sort of base understanding in order to understand why the case law matters and what the courts are talking about. If you already know this, then just bear with me, it won't take too long. So there are two layers to termination entitlements in Canada. One is employment standards minimums, and the other is common law maximums. The employment standards minimums are set by statute or legislation, and the legislation is different across provinces, but the minimum termination entitlements in each province are about 1 week for every year worked, up to a max of about 8 to 10 weeks, depending on which province you're in. In Ontario and the federal jurisdiction, there is also something known as severance pay, but we're not really going to talk about that because that's very case specific, and I don't want to muddle things up for you, so we're going to leave that out. But the common law entitlements, on the other hand, are termination entitlements set by judges through case law. And the common law entitlements are often described as being the maximum entitlements because an employee can get up to about 1 month for every year worked, and that goes up to between 24 to 30 months. Again, that's depending on which province you're in, but these maximums are constantly being challenged, as we'll see later. So let that sink in. The maximum termination entitlements are between 2 to 2.5 years for employees, which is a lot. And I will say too that this 1 month for every year worked isn't an exact science, and we call it an art, but I don't know that it's that either. But there are many reasons why the entitlements can increase, including the employee's age at termination, availability of comparable work, their level or position. And the only way to be able to pay an employee the minimums versus the maximums and to have them forego the maximums is by way of a valid written employment contract with enforceable termination provisions. So for illustrative purposes, let's say you have an employee that's been with you for 10 years and you have to terminate their employment for whatever reason, without cause. With a valid contract, you can pay that employee between 8 to 10 weeks in order to terminate them, depending on where you are. But without a contract, or with a contract that has a bad termination provision, what you're actually going to pay is maybe between 10 months to 12 months, right? So between, and I should say too that 10 to 12 months could go higher, again, depending on the employee's specific circumstances. So if you have an older employee, for example, you might see that tick up to 18 months, 24 months, right? So with such a huge disparity in liability between having a valid contract and not having one, you can see why every time a court decision invalidates a termination provision, employees or employers rather are devastated, and they have to go back to the drawing board to review their contracts and try to make changes that will ultimately be upheld by the courts. Now, the second thing that I want to touch on, because we're going to talk about it, is the Wakesdale principle, or at any time language. So Wakesdale and Swegan was a case that was decided in 2020, so right smack dab in the middle of the pandemic, in Ontario. And Wakesdale essentially fundamentally changed contract interpretation by saying that termination clauses have to comply with employment standards legislation at all times during the employment relationship, and not just at the moment of termination. So courts now assess clauses by asking, could this clause ever operate in a way that violates statutory protections, even hypothetically? So this is where the phrase "at any time" becomes legally dangerous, because if you're telling an employee that they can be terminated at any time by you providing them their minimums, but the Employment Standards Act says that you cannot terminate employees during certain times, like during protected leaves, such as like a sick leave, maternity leave, parental leave. These two things are not compatible. You cannot, on the one hand, say you can terminate at any time, but be in violation of the Employment Standards Act that says that you can't terminate at certain times. So those clauses could theoretically violate employment standards protections, even if the employer never actually intended to do that and isn't in fact doing it. You could be trying to terminate an employee who is not on a leave, but that doesn't matter. It's the hypothetical that matters, right? So with that in mind, we'll go to the next slide and take a tour through, if I can call it that, the tour of the enforceability crisis. So first we go, and these are all 2025 cases. First we go to Baker. And in Baker, this is an Ontario case. The employer attempted to address the Wakesdale risk in the contract by including language that acknowledges employment standards protections during statutory leaves. But despite that, the court struck down the termination clause entirely because the clause permitted termination at any time, only with minimum entitlements. So the court held that even though other parts of the agreement attempted to preserve statutory rights, the core termination language still could operate unlawfully, hypothetically, during protected periods. So the key takeaway from Baker is that courts are not willing to piece together compliance from different parts of the contract. If any part of the termination clause is non-compliant or is in any way ambiguous, the entire provision fails. And this reflects the court's strict literal application of Wakesdale, and it puts employers on notice that partial fixes are not sufficient. So what happens if your termination fails is that your employee is now entitled to the common law maximums versus the minimums. Then we have Lee and Wayfair. Lee represents the opposite end of the spectrum and directly conflicts the decision in Baker because the court upheld a termination clause that contained the "at any time" language, but only because the judge said the agreement, if read as a whole, clearly and repeatedly preserves statutory protections, which is the exact opposite of what happened in Baker. So the court accepted that in context, even though this "at any time" language appears in context, the clause couldn't reasonably be interpreted to permit an ESA breach. This was fantastic. It's more employer friendly and it's a purposive interpretation of the language of the contract, but it creates uncertainty because now we have this directly conflicting decision with Baker. So then we have, sorry, can we go back to, oh no, we're on the right slide, sorry. It's just on my end here. Then we go to Jones and Strides, which kind of pulls the pendulum back towards strict enforcement. And here, even though the employer tried to carve out statutory protections, like the employer did in Lee, like Wayfair did, the court held that the presence of the anytime language still rendered the clause ambiguous. And they emphasized that the ambiguity in the termination provision alone is fatal, and particularly where that ambiguity affects minimum statutory rights. So where do we stand? I know that Lee is going to be appealed at some point. We don't know when that decision is going to come down or if there's going to be a settlement. So at this time, what we are advising our clients is to stick with the strict interpretation. If you go back to your contracts, to your termination language, and you see that those, at any time, those 3 words, you still are in danger of having an invalid contract, and you should be updating your contracts. But with that in mind, Birch, we have if we can go to the next slide, we do have a decision in Birch, which is, I would argue, the most important termination clause decision of the year of 2025, because it actually finally provided appellant level clarity on what is a good termination clause. Because so far what we've gotten through case law is what isn't a good termination clause, what's going to invalidate your termination clause. So in Birch, we have a termination clause that affirmatively guarantees compliance, and the court has upheld that. The court said that there was no attempt to rely on implied protections or saving language elsewhere in the agreement. And because the clause explicitly preserved employment standards, minimum notice, benefits continuation, protection during statutory leaves, protections through the entire employment relationship, they found that the clause couldn't reasonably be read as limiting statutory rights, even hypothetically. So it complied with Wakesdale. So the drafting lesson was clear here. Courts are not going to be tolerant of close enough language, and the employers must draft termination clauses that are unambiguously compliant. So now what we have is that Birch is our gold standard for termination provisions, which is fantastic. A few other cases, if we can move to the next slide, of importance. We have Gasvini and we have De Castro. They're from different jurisdictions. Gasvini is federal jurisdiction, and Arista is, I believe, Ontario. And they have to do with invalidity in the termination provision due to issues with the for cause section of the termination clause. So far, we've been talking about the without cause section, and you're telling employees what's going to happen if you can terminate them at any time or not. Without cause, this has to do with the with cause section. In both of these cases, the issue was how employers defined cause in their contracts. And the termination provisions permitted summary dismissal or termination without notice or pay for conduct that fell short of the common law standard for cause. So some of these provisions said that you can terminate, that cause would be if there were performance issues. Cause might be for some other lesser misconduct. And what the court said is that these types of clauses improperly expand the concept of cause, because what the law permits is not that wide ranging. So because the clauses allowed termination without notice in situations where notice would legally be required, the entire termination provision was invalid. Again, these employees were then entitled to common law maximums versus the minimums. So the takeaway here is, if you go back to your contract, your termination clauses, and you find that you are defining cause, whether it's wide or not, I think that what my advice usually is that if you're defining cause, you are at risk of that definition being too broad. So I always tell my clients, just don't define cause. And in some jurisdictions like Ontario, there is no just cause. It has to be some other standard. It has to be willful misconduct, etc. So my advice is don't do that. Don't define cause if you can help it. In Miller and Aaliyah Care, this was, again, 2025. This was a case out of Ontario. So here, the issue was around inducement, or inducing an employee to join the organization. In this case, Miss Miller was age 62. She was induced by Aliyah Care to join them as a VP from secure employment where she had been employed for 12 years. Aliyah Care actively pursued Miss Miller through direct recruitment efforts. They offered her substantial financial incentives. They gave her assurances of an executive position with significant responsibility, and they agreed to indemnify her against potential litigation by her former employer. And so it turned out that she was not working out. She was terminated after just 7 months of employment. But the court found that because she was induced to leave secure employment based on Aliyah Care's significant promises, they awarded a notice period of 12.5 months, just over a year, which far exceeds her 7-month tenure. So this case highlights important considerations for employers recruiting senior talent from secure long-term roles, and specifically recruitment practices directly affecting termination exposure, which is something that employers either are not aware of or they underestimate. So beware of that. Two similar cases, one out of BC, one out of Alberta, but very similar outcomes, where employees who were working remotely, one I believe started as a remote worker, the other one did not start as a remote worker but was allowed to work remotely, and then both were recalled full-time into the office. And what happened was that the courts in both cases said that where employees were hired remotely or worked remotely for an extended period, a unilateral return to office mandate is going to be found to be a fundamental change to the employment terms. So the key lesson here is that employers have to carefully assess whether remote work is either a fundamental part of the employee's contract or has crystallized into being so, even if it didn't start that way. And I think that's particularly timely now with organizations fully recalling everybody back to work. Yeah. And then finally, I'm aware of the time here, I'm taking more than my share, but these are really important. And so the last one is out of Alberta, I think, again, and it's Lischuk and KJ Electric, where Mr. Lischuk, who was 58 years old, he worked for KJ for 34 years. So since his youth, since his 20s, he only ever had any other experience as a laborer in his 20s. So he had nothing else on his resume. And his position was, a high-level general manager. And he was a key employee for many of those 34 years that he had worked there. And the court in this case awarded Mr. Lischuk 26 months of reasonable notice, which is an exceptionally high figure, especially in Alberta, where previous case law had sort of established that 24 months was the cap. So what this case makes clear, and it's not just the number, but it's the signal that the court is giving, which is that courts remain willing to award very long notice periods in certain cases, particularly where there's no written employment agreement or where the termination clauses in an agreement fail. So this, again, reinforces why enforceable contracts are now a frontline risk management tool. It is of utmost importance to make sure that you can manage termination liability. So I've taken more than my share of the time. I'm going to pass it on to Tom at this point.
Okay, great. Thanks, Libita. I don't know if I'm up on the screen or not yet, but I think I am. Yes. Now, moving from the world of judge-made law and the common law, Libitza was talking about, we're going to move now to legislative updates, which are more concrete, potentially a little bit more straightforward to in terms of lawmaking, and they're the ones that can actually result in some of the more concrete operational changes for our clients. So much of employment law is common law, but a great deal of it, as we know, is statute-based, including employment standards and occupational health and safety, and privacy law and human rights law. So with that in mind, I'm going to do a quick tour around the country. We have, of course, a federal system here, so I'm going to start by talking about Ontario, and then some developments in our western provinces of beautiful British Columbia and Alberta, and Manitoba as well. And I'm going to conclude with some quick highlights of what's happened at the federal sector, to the extent that any of you are covered by that. So some of the themes of the reforms this year, there hasn't been thankfully anything too groundbreaking, or any major overhauls of statutes that you do see sometimes. More in the very technical refinements to certain rights and certain procedures, and nothing that's going to fundamentally change the way you have to do business and manage your employees. There's expanded leave entitlements, which I'll talk about briefly, and then there's a greater focus on what's called transparency in hiring and recruitment, which has introduced some kind of interesting new requirements on employers and recruitment agencies, and along with that, some enhanced enforcement mechanisms. So turning to Ontario first, the major development, obviously, in Ontario last year was Bill 30, called the Working for Workers, I believe it was 7 Act. I'm not sure, there's been quite a series of them under this government, but it's another significant step in some minor changes to employment standards. So there's a couple of areas that have come up that are kind of interesting. One is the focus on artificial intelligence, which of course is extremely current today, and it's being used very widely in all facets of our economy. And so there is some focus on AI transparency. That means the need to disclose whether you're using AI in screening, assessing, or selecting candidates. And as we know, there's a wide range of AI tools. So right now, the reform captures resume screening software, for example, automated ranking systems, algorithm shortlisting, etc. So I think it's not saying that using AI is wrong in any way, but it's requiring that if the use is made, that it be disclosed. So in practice, that means that if there is any kind of AI usage going on and there's not a disclosure, then potentially down the road, there could be a compliance issue that arises. So it's best to be on the safe side of that. That reform came into effect just actually early this year. Then there's the pay transparency, and this is also embedded in some of the reforms specific to the ESA 2000. But the gist of it is that public job postings must now include salary ranges. And the widest the range is allowed to be is $50,000. And so that's kind of a major change in certainly in a bit of an intrusion, one might say, into the internal decision-making processes of a recruiting employer. So what it means in practice is that your job posting templates may have to be reviewed. Your recruiting agencies need to be updated on what's the best practice here. And obviously, you need to take a look at your internal compensation structures to be sure that they align with what's represented in job ads going forward. And they apply to current and future job postings. And so you'll need to audit your career pages, your external recruitment platforms, and recruiter managed postings if you engage professional recruiters to assist you as well. So The salary ranges also have to be what's defensible, in the sense that posting artificially wide or misleading ranges may undermine the purpose and attract scrutiny. So the big takeaway is recruitment is now part of the regulated process of employment, which wasn't always the case. The point of formation of the employment contract is usually where employment law began, and what happened before that was very seldom scrutinized by statute. But now it has changed in that regard. And then, as I mentioned, there's been some additional leaves. I won't dwell too long on these. There's been a new job-seeking leave, which came in force last November. And these, again, are out of Bill 30. And it applies when 50 or more employees are laid off at the same time. So it's not the most common, going to apply all that commonly. But it allows people to essentially have up to 3 unpaid days to essentially help them look for a new job. So there's some details to that, but I won't get into those. Also, there's a significant reform to the temporary layoff rules. Now, the normal rule is 13 weeks before a temporary layoff is deemed to become a termination under the ESA. But now there's a provision, again coming in last November, that allows for extended layoffs of 35 or more weeks within any 52-week period for non-unionized employees. It cannot exceed 52 weeks in a 78-week period. However, it does require a written agreement between employer and employee. So it's not something you can do unilaterally like you could a 13-week temporary layoff. It also has to specify the recall date, and of course it needs approval from the Director of Employment Standards. And so that places a bureaucratic kind of hurdle in the way of that. But that's a new provision for employees who want to take an extraordinarily amount of time without you having to sever or them having to resign. So that may provide some additional flexibility in those situations. In line with the AI rules that I was talking about before, there's job posting platform accountability rules now that just came into effect this January, which is less aimed at employers and more aimed at the operators of online job platforms. Essentially, it requires them to implement mechanisms for so-called fraudulent postings and post their policy online, and essentially trying to make them be a little more vigilant in monitoring the content in their platforms. So that's the Ontario situation. And I think we can probably go to the next slide. Taking, I know that we have a number of fantastic clients in British Columbia and Alberta and Manitoba as well. And we always try to keep abreast of legislative developments in each of the provinces. And in this past year, there has been some uniformity in the kinds of reforms that have been made. Starting with British Columbia, there has been a 27-week illness leave, and you'll see that this has been replicated essentially all through the 3 provinces. But essentially, it's a extended medical leave for workers facing serious health challenges. And what it allows for is an extended leave that goes up from the normal prescribed timeframes in the statute. In Alberta would be the Employment Standards Code, BC would be the ESA, Manitoba Employment Standards Code. And it creates this new, longer, more enhanced form of leave that provides more flexibility, similar to the extended layoff provision in Ontario, although that's not a medical related layoff. So that's a significant development in each province, so I won't repeat it when I talk about Alberta. One of the other interesting developments also in British Columbia has been this ban on sick notes, which brings British Columbia into line a bit more with Ontario. And when I say a ban on sick notes, it sounds rather extreme, but Bill 11, which actually came into force last November, has a new provision that prohibits employers from requesting sick notes for health-related leaves of 5 consecutive days or less. However, it applies to the first 2 such absences in a calendar year, so there is a cap on it. It excludes maternity leave, parental leave, and some other kinds of leaves. So there are exceptions to it. If it's longer than 5 days, you can ask for a sick note. Or if it's a third or subsequent health-related absence, again, you can ask for that. So it's like Ontario, which has a requirement, a window within which the employer cannot ask for, but after that point, it's certainly something that can happen, can be requested. And of course, it doesn't disturb the employer's existing right to request information relating to fitness or return to work or accommodation needs. So that's one of the new legislative reforms out of British Columbia. And of course, there's also been reforms, as you'll see, related to pay transparency, which I won't dwell on. They're very similar to the ones in Ontario. And then moving to Alberta and Manitoba, I'm sorry, I missed the gig worker protection as well. Gig workers are now a classified category of employees. And these would include so-called freelancers or people who work through apps, delivery employees and so forth. So there has been some extension of the workers' compensation coverage for them as well. So it does create some interesting legal questions about the line between independent contractor and employees for those kinds of jobs, such as, for example, DoorDash drivers or Uber drivers, etc. So that's what those reforms are aimed at. And then, so moving to Alberta and Manitoba, I've already talked about the enhanced 27-week leave. There's also been some Occupational Health and Safety Act reforms in Alberta involving nothing too concrete or that it's going to have any major implications for how you manage, but it does require that you consolidate all of your violence and harassment policies into one consolidated policy and prevention plan. And so really at the end of the day, it means you need to consolidate, review your policies and conduct additional training in line with those. And again, the extended medical leave was also brought in Manitoba in 2025 as well. So those are the major reforms in our Western provinces that took place in 2025 that we focused on, that we thought were important. And then I think we go to the next slide. We wanted to touch briefly on the Canada Labour Code, our federally regulated employers, clients who are in federally regulated business, such as transportation, aviation, and Indigenous employers as well. So there have been a few amendments to the Canada Labour Code, as they always do every year. But there's just a couple of areas, like at the provincial level, there's been an expansion of medical leave to allow employees to take time off work for serious illness or injury without jeopardizing their employment. It is actually a job protected leave, so it exists sort of in parallel to existing human rights and duty to accommodate obligations. So it remains to be seen how that's going to apply in conjunction with those existing obligations. But it is similar to what we just saw in the Western provinces as well, in the extension of an extended form of medical leave that can go past, potentially 6 months. And then there's been a couple of family-related leaves, personal leaves, and I won't go into all the details. There's leave related to pregnancy loss, enhanced bereavement leave for that on top of the existing bereavement leave rights. There's now also a leave for placement of a child in an adoption. So it would be something that puts adoptive parents on par with biological parents. And then one of the interesting things that hasn't come into law yet, but it's been it was in the 2025 budget, is a proposed new restriction on non-competition clauses, which is found already in Ontario. It's a statutory prohibition on non-compete clauses, and that's expected to come into force sometime this year, early this year. So we'll keep an eye on that as well. But overall, as I said, the changes have been just sort of adjustments to existing entitlements and obligations. And of course, there's been enhanced protections for the vulnerable workers, of course, including the gig workers, of course. And there has been, I won't go into the details, but they've tightened up some of the potential penalties and fines that can come from non-compliance with certain statutory entitlements. But overall, the Canada Labour Code structure remains the same, where employees, depending upon how long they've served, can have access to different kinds of termination mechanisms than employees regulated by one of the provinces. So those issues will remain. Really, the Canada Labour Code changes have been more in terms of expanding the leave entitlements. So overall, that's the changes on the landscape legislatively here in Canada, and we wanted to share some of those changes with you, and certainly can help you adjust and adapt to any of these additional leaves and new requirements that your employees may come forward with. I think we can go to the next slide. Yeah, so I thought I'd recap some of the themes from today. As Lubisa noted, the courts are scrutinizing employment contracts more aggressively than ever. And so it's always good to stay on top of your contracts, and especially the termination clauses, and have them reviewed, especially for new employees and new hires. And as we've seen, the legislators across Canada have been busy refining some statutory protections. So the takeaway for employers is that it's good to be proactive and constantly, review your contracts, and be mindful of the potential implications of any of these new changes on any practices or procedures that you have in place. And it may be time to also review your policies and consolidate your policies. For example, if you are a federally regulated employer and need to consolidate your violence and harassment policies. So appreciate you taking some time to listen to our overview here, and I think we can maybe get into some questions.
Perfect. Well, thank you so much, Tom and Luvisa. That was amazing. A lot to cover there, definitely.
Yeah.
And the one thing too, I'm going to put just a very, very quick timeout before we jump into QA, because I want to make sure everyone that's here isn't just taking notes. Also, remember, you don't have to tackle this stuff alone. Everything we're covering today, it really becomes real when it turns into a decision for your particular situation. Like, what's the safest way to handle this? Are we exposed here? What do we do next? And that's where it gets a little bit difficult to apply it to those actual situations. And that's really where we come in. So one thing that's really unique about HRC law is that we are an unlimited subscription style legal support, which is amazing. You can reach out as much as you want. There's no surprise charges. If you're like me talking with my lawyer way back in the day, he'd talk about his dogs for 10 minutes and I'd be like, am I getting charged for this? I don't know, right? But you know what? This way it's predictable, it's affordable, it's built for all that real stuff that takes a lot of back and forth, like tricky terminations, custom employment agreements. And if you get that dreaded letter from a lawyer, we don't want to deal with those on our own, right? You're not Googling, you're not guessing. You've got a full team behind you for support. One thing I will tell you too, because you're here today and we love all of our webinar viewers so very, very much, we're doing something we've never done before. 2 webinar only offers. They're going to be available till February the 15th. This one is something brand new. We've never done this before. It's like a little trial with our wonderful lawyers here at HRC Law. You're going to get 6 months of unlimited legal or law advice for employment law, and it's going to be a flat fee of $1,000. No obligation to continue with that. But I will tell you, everybody that gets started, they are super addictive because they are so helpful and wonderful. And I know you're not going to say no after that. And there is also, for people that need extra support, we've got bigger, more robust legal programs here as well. And on anything like that, you're going to get 25% off your first year. If you want details, you want help choosing the right fit, anything like that, reach out to us, service@hrcovered.com. Put in the subject line, webinar legal. We're going to send you the info. We can book in a time to chat and just help you make the decisions for what's right for your situation. All right, let's get into those questions. And funny enough, the first one here is asking, how can we get more of a one-on-one with legal law for employment law? Does HR Covered help offer something like this to its members? Absolutely, we do. Easiest way to get in touch with them, we've got all different kinds of programs as well at HR Covered, and because we work so very closely with HRC Law, we can get you over to them directly. Just put in your subject line when you email service@hrcovered.com, put account manager up there. We're going to get you to your account manager and they'll tell you exactly what you have included with your program, how to get there, and you'll be able to speak with them directly there. Next question here, regarding the clarity of clauses, does this mean that clauses containing cross-references to other clauses can still be considered compliant?
I'm happy to take that one. Like many answers in our field, the answer is it depends. What the cross-references to? If the cross-reference is to a term that's not compliant, so we have a few cases from a few years back where there was a restrictive covenant that essentially said if you solicit if you do X, Y, and Z, then you will be terminated with cause, right? Mm-hmm. So that is not compliant with employment standards, as we saw. And so if you're cross-referencing to that section of your contract, then you're practically invalidating all of your termination provisions, and not just one part of it. And that's consistent throughout case law. And again, you can't choose and pick which ones you're going to rely on or which ones you like. The entirety of your termination clauses, including your cross-referenced clauses, have to be valid. They have to be legal in order for your entire termination clause to be upheld. I hope that answers your question.
Yeah, absolutely. That was great. Thank you so much. Next question here. What is your recommendation for agreements in force already with employees that have at any time language in them?
Yeah, I can take that. I think I think it's a great question. Comes up very frequently. Certainly, it's one thing to say here's what you should change in your contract going forward, but when you have existing employees, you have to be very careful. Obviously, with both the content of what you present and the process and how you message and communicate with them about it. So in the case of at any time, you want to take, for example, your termination clause and update it to remove that language. It's possible to approach the employee and present the new contract, so to speak, and in the this is where the process comes in. You really want to be as candid and forthright about what is the change and the why, because if the employee doesn't understand, if they just see a change for change's sake, it makes any of us, I think, would instinctively get a little nervous about what's the real reason behind this. So if you can have ready to go, we were told by our lawyer or something to have this, but one of the things that can sometimes happen when you do that is they will go away to a lawyer, bless their heart, go to an employment lawyer, and get advice that they're not to sign that, because you've caught your employer in a bad termination clause, and you don't want to give that up, something along those lines. And they come back to you, and it can lead to a little friction. So it's obviously best to get legal advice and consulting advice before approaching an employee like that. Certainly for new employees, none of this applies, but existing ones, particularly ones of 10, 15, 20 years, they may go get that advice and come back to you and say, not so much. And you can still, say that's all good, forget it, whatever at that point. The real risk would come in when it's presented as like, we're doing this regardless kind of thing. So long answer to a short question, my apologies, but yeah, it's a delicate process. You want to get some advice on that for sure.
Yeah, no, that definitely makes sense. And kind of follow-up question to that, because the courts are keep changing the rules and that sort of thing. How can we as employers keep trying to update existing contracts without constantly facing, this is more specifically, constructive dismissal risks from employees?
I could take that one. So just along the lines of what Tom was saying, is the way to update contracts without constructive dismissal is by giving appropriate consideration to your employees. And consideration is sort of a legal term that means that your employee is giving up something. So they're signing something, or they're signing away some of their rights in allowing you to take away their common law entitlements. So you, the employer, have to give up something as well. And continued employment is not sufficient consideration. It has to be something extra over and above what the employee is already receiving. And so by giving consideration and having the employee's agreement to sign a new contract, then that's how you get a new contract in place with your existing employee without facing constructive dismissal risks. Otherwise, if you don't have that, or if you unilaterally try and put something in place without the employee's agreement, again, it's not going to work. Like Tom was saying, you're going to be in a world of trouble. And so that's how we do it.
Okay, perfect. Thank you for that. Next question. I like this one. Our organization is Canada-wide. For these provincial legislative updates, are we required to comply with all of them, or just the province where our organization physically operates? And in this case, it's Ontario.
Yeah, great question. I think the latter, just where. So if you have like 4 employees in Ontario, 4 in Manitoba, and 4 in BC, and they are there on, working remotely, or they're there all the time performing their work in those places, then the law of those provinces only would apply to them. So you wouldn't have to make them comply. If their contract said as the place of law, named a different province, it could get a little complicated at that point, but the default would be, the law of where the employee is doing the work is the default of the province that would apply, or federal if it was federal. So yeah, you just gotta pick one and go with it with each employee kind of thing.
Excellent. That's so good for people to know, because I know in this day and age there are a lot of companies that have remote workers in all different pockets.
We're all sewn together as a great economy.
Absolutely. Okay, so we have a little bit of time left. I'm going to put a few more questions through. If we don't get to your questions though here, we will reach out to you afterwards.
Yeah.
I can see there are a couple questions coming in. Will this be recorded, sent to us? Absolutely, it will. We usually get them out. We try to get them out by next day. So maybe tomorrow, maybe on Monday, but we will definitely send it to you because you've registered for the webinar here. We have a question too. As an HR covered and HRC law member, Do we need to request the new contracts, or will they be sent to us? And will they have all the changes? And I can actually answer this one here. Absolutely. We do updates pretty frequently, but if you miss them, I always tell people we're unlimited. When you've got a new worker coming in, you don't have to worry about all these other hoops that we were just talking about that you have to jump through. Just reach out to us. We will send you the latest, greatest. I think that's best practice. Every time you hire, just reach out. We'll send it. That way you don't ever have to worry about having something there that's out of date. Okay, next question. Regarding our current employees, oh, sorry, this is the same question here, pretty much. I'm going to skip over this one. Regarding protected leave, so unpaid sick leave, was there an update or clearer eligibility criteria or measures for long-term leads that are exceeding 1 month that directly impact an employer's operations, for example, to prevent misuse?
In terms of the new sick leaves, yeah. Honestly, that's in terms of a mechanism to put they do have certain caps and certain eligibility conditions that the employee has, and I think it sounds like they're asking about mechanisms for if employee misuses it in some way. I think don't have the specific wording in front of me, but I think that probably would fall under like with any kind of leave, if there's been misrepresentation or dishonesty, then that becomes a sort of a performance or misconduct issue of the employee separate from the leave itself. But I know that the right to ask for medical information kicks in after 5 days, for example, under the new, depending upon what province you're in, but it kicks in after that time frame, and that's sort of the check and balance against misrepresentation. Is you're entitled to ask for receipts, as they say, and prove that this was medical. So I hope that answers the question. If not, feel free to follow through, send it in the afterwards, and we can follow up on that.
Yeah, absolutely. And whether you're a client or not, send us an email, service at hrcovered.com. We'll be happy to hear from you. And I think we have time for one more quick question here. We actively recruit from competitors. How do we reduce inducement risks in offers and onboarding?
That's a good question. So the best way to do it, in my opinion, and when we draft our contracts, we put this into new contracts specifically where there has been active inducement, is to say that we are not inducing you from secure employment. You understand, so it's just being really very clear and blatant. You understand that once you leave your other employment, that's not going to be counted towards your common law entitlements if you happen to have any at the end of our relationship. So that's kind of the best way to do it, because in this economy, I think you potentially sometimes need to have those active, aggressive recruitment methods. So to forego those, like, I can't really recommend that to you. That would be the safest thing, but the next best thing would be to have that clause in your contract to make sure that your employee understands exactly what's going to happen upon termination.
Yeah, no, that's great, because I know that can get real expensive real quick if they've been at the company before for a long time. So that's wonderful. Well, I think we're just about at time. Again, we will definitely send this webinar recording out to you. Thanks so much, Tom and Labisa, for all of this amazing information.
Fantastic.
Thank you. And thanks everybody for attending.
Yes, thanks for everyone for coming. Good to be with you all.
Fantastic. And before we go, quick reminder, we'd love to see you at our next webinar, termination traps small businesses fall into. So anything to do with terminations that are commonly happening, we want to make sure it doesn't happen to you. It's going to be happening February the 12th at 2 p.m. Eastern. It's going to be a really useful session. We're going to have concrete examples, of course, and some clear takeaways that you can apply right away. So thanks everyone again, and enjoy the rest of your day.
Thanks, Kim.
Thank you. Bye-bye, everyone. Take care.
Take care.